Namo Siddhanam, Namo Ayariyanam, Namo Vajayanam, Namo Lohisavasahunam, Eso Panchanamokaro, Sarva Pava Panasano, Mangalanam Chesavisyam, Padamam Havai Mangalam, Padamam Havai Mangalam.
நீராரும் கடலொடுத்த நிலமடந்த கெழிலொழுகும் தீராரும் வதனமெத திகழ்வரத கண்டமெதில் தெக்கணமும் அதிர்சிறந்த திராவிடன திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த சீரிழமை திரவியந்து செயல் மறந்து வாழ்த்ததுமே வாழ்த்ததுமே வாழ்த்ததுமே.
Today we have with us Ms. Nidhi Agarwal. She is a co-founder of Path to IP LLP. Nidhi Agarwal is an intellectual property professional with extensive experience in IP. Additionally, she has prior research work experience in CSIR Lucknow. She has done several prior art searches and patent filing for MNC, government organization, and individual inventors. She co-founded Path to IP, the mission to support inventors and business in protecting their ideas, intellects, and innovations using IP law and services. She is a registered Indian patent agent and MBA in pharmaceuticals, postgraduate diploma in patent law. Just to have a brief introduction about their organization, Path to IP LLP is a firm providing intellectual property services, including patent, industrial design, trademarks, copyright, and geographical indications. It also offers consultancy and opinion on IP-related aspects. The Path to IP team has extensive experience in IP searching, analytics, drafting, filing, etc., providing IP services in varied technology domain like chemistry, pharma, engineering, FMCG, etc. Thank you so much, Nidhi ma'am, for being here, and we are happy that we were here. You were here yesterday also, and looking forward for your session, ma'am.
Thank you, Deepa ma'am. I am feeling very honored, and thank you for this warm introduction. I am really looking forward to this great learning session. So, should I share my screen?
Yes, ma'am.
Do I have rights? Okay. My screen is visible? Excuse me, can you please confirm about my screen is visible?
Yes, ma'am. Yes, ma'am.
Okay. And let me do it in presentation mode. So which mode you are able to see it? Is it reading mode or presentation mode?
Ma'am, it is visible and it is in reading mode only, ma'am.
Reading mode. So you are able to see two slides or one single slide?
Single slide, ma'am. I think you have shown a slideshow.
1 and 2 both are visible. Okay. I think it's now completely visible on.
Yes, ma'am.
Okay. So, good morning, everyone. And let's start with the today's agenda, as ma'am has introduced me and my company as well. So, as we have learned about different types of intellectual properties, and we learned about patents, we learned about industrial design, copyright, geographical indication, and as well as we learn about patent. Uh, one IP is missing, I think. Trademarks. So all these intellectual properties are our intellects, our ideas, our creativity, and we can protect these ideas, intellect in different ways, and using these rights we can protect our ideas, and such ideas should be protected using the rights which government provides, and different in different ways, and we it should be protected because it is helpful, and it is good for public welfare as well, and good for societies. So such ideas should be protected. So with this, let's start with the agenda. So today our agenda is to learn about what is prior art. So as these IPs, patents, trademarks, such IPs are available, but when we get some idea, how we will validate these ideas that it is new or it is not available. So so we will learn for that there is one more thing which is called as prior art. So what is prior art? We will learn about prior art, who can perform the prior art search, why to perform prior art search, what is the relevance. So we will learn about it, what is the type, what are different types of prior art search, how to perform it, and what are the various search engines, what are the various databases available. And then we will have a question answer session or discussion session. So let's go one by one. So first is, what is prior art? Just a minute. Yes. So what is prior art? We why I'm not able to click it? Okay. Yes. What is prior art? So prior means before, which is already available prior, and art, any article, anything which may be in the form of article, and or any blog, or any patent, or any NPL. So prior art. So any information which is available in public domain throughout the globe, throughout the world, is called as prior art. Any information. So for example, I am doing any search today. Today is 25th, and I am doing any searching for any idea. So before of that, whatever is available in public domain throughout the world, which that is called as prior art, it should have an effective date. That article which is available in public domain, that should have an effective date in on it. So with a date throughout the globe, anything will be called as prior art. It may be in any format. It may be in physical form, means any paper, or any electronic format. So, for example, any published article on social media, for example, LinkedIn, Instagram, anything, anywhere, if it is having any date, that would be considered as prior art. So, what are the different examples of prior art? So, any patent or patent application, any research paper, conference paper, any magazine article, or any commercialized product which is available on any shopping site, for example, Amazon, uh, or any shopping site, Alibaba, anywhere it is available, which is having the same idea or same concept, or any clinical data, or any website, shopping site, social media, because nowadays many people promote their products on different social media, Facebook, Instagram, or they publish their article on LinkedIn, they publish their article on WordPress. So anything which is having the information related to an idea will be considered as prior art. So, who can perform prior art search? So, any person who is directly or remotely associated with an innovation will can perform that prior art search. So, if I am an inventor, I am working as an individual inventor, so I can perform that prior art search. Any R&D team, if a company is having a big R&D team that and getting an idea, that R&D team can perform that prior art search. Also, that company may be having an IP department, also intellectual property department. So that team can R&D team can give that task of prior art searching to that IP team, or it may outsource if it is that company is not having IP department, that there in that case it can outsource that prior art search performance to any outsider team or any marketing or business development team. Why these people are can perform? Because R&D, business, and IP, all these things go all together. Because marketing or business development team is going to promote a product or is going to launch a product, so they should know that idea or that innovation should be should is able to be launched in the market or not. So that business team or marketing team is can perform that prior art search also. So these people can perform. Now let's learn that what are the different types of prior art search. People have a misconception that that when a person is going to file a patent, then only they can perform a prior art search. But actually it is not. There are different types of prior art search, and that searches can be performed on different stages. So for example, one is patentability search, second is freedom to operate search, third is technology landscape, and invalidity search. And these searches are performed on a different stages of a product development and or R&D stages, and they have different relevance. They have different importance. So let's look at what is the actual stages of a R&D or product development, and where all these searches are can be performed. So, for example, when you have come up with an idea, suppose you have come up with an idea, for example, a new shampoo, which is having a conditioning effect, and which provides the property of which relieves with the frizziness. So now it is just an idea, and now you want to launch that product, but what are the what is you want to validate your idea, and for that you want to know that what are the already available solutions, what are the available patents in the market, and is it worth to launch that idea in the form of products. So on the basis of that, there are three stages. One is idea, which is just you want to solve a problem, and you have come up with an idea. So you want to start with the research. So for that, on that stage, three types of searches can be performed. One is technology landscape. Second is wide space analysis, and third is state of the art. So technology landscape gives a complete snapshot of a technology, that these are the different solutions, these are the different technologies, and these are the competitors already available in the market who are working in this field already. Then you have validated your idea, and now you have done some R&D. Now you want to file a patent. So before that filing, now you want to check that is it worth to go for filing, because filing is also having some cost occurrence. So would it be worthy or not? So for that thing, a patentability search is run. So in patentability, there are different criterias which are performed, which are checked during patentability search. We also will learn every search one by one. Here I am giving a view of which search should be run. And then next stage, you have filed the patent, it got granted also. Now you want to launch your product. So now in that stage, if you directly launch your product and you don't know the consequences, and when you launch the product, some other people, some other inventor or patent holder come to you, and they send you a lawsuit that this is already my product, you are infringing my patent, because I am already having a patent on this product. So how you can launch your product? So to avoid that conditions, that issues, that lawsuits, you perform FTO analysis, which is freedom to operate analysis. And further, there is one invalidity search, and based on that you take other decisions. So we will learn all these things all together slowly, one by one. So next is, which is the first search, called as patentability search. So patentability search is run to determine whether an invention or idea is novel, non-obvious, and possess industrial applicability. So it helps to decide how to draft or amend claims to ensure that it can be protected by a patent. So for patentability search, for checking that patentability, there are three criterias. One is novelty, second is inventive step, and industrial applicability. So in case of novelty, an invention is considered novel if it does not form a part of global state of the art. It means it should be completely new. There should be no any available information related to that specific invention which you have done. So it should not be published anywhere around the globe in any form, like magazine, any technical journal, newspaper, books, web content. In any form, it should not be published. Second is inventive step. So in case of inventive step, uh, okay, you have come up with an idea. Uh, maybe you have combined two inventions in the form of one invention, and a person who is skilled in that invention, in that art, uh, that invention which you have combined is obvious to that person. So this thing also get checked, that it should not be obvious to a person who is skilled in the art, who is already knowing that type of invention. So it should not be obvious. So there should be an inventiveness. Third is industrial applicability. It means it should be useful invention. So in case of novelty is in, let's go next slide. So novelty. So according to section 2JA of Indian Patent Act, the definition is read as a feature of an invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both, that makes the invention not obvious to a person skilled in the art. So this is the definition of novelty. So novelty is an important criterion in determining patentability of invention. One more way of running patentability search. There is a one separate search which is called novelty search. So in that case of novelty search, it is just checked that there is no other prior existing art available. So in case of novelty search, we don't check the inventive step, we just check the novelty criteria. Because what happens in case of inventive step, there is no defined definition of skilled in the art thing, that who are those person who are skilled in the art. So that definition is not still available anywhere. So based on that, that novelty search is performed. If patentability search with inventive step is also performed, so in that case we perform both things, but generally it is a trend of search performing novelty search. Next is the definition of inventive step or non-obviousness in according to Indian Patent Act is a feature of an invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both, that makes the invention not obvious to a person skilled in the art. So in case of that, there is, for example, you take an example of bulb, which is already available in prior in public domain since long. But slowly one more type of lights, which is LED bulb, come up with the time. So LED bulb, what is the uniqueness or what is the inventive step in LED bulb is it provides it slowly gives the cost effectiveness. Maybe during purchase it is not that cheap, but the electric consumption is low as compared to bulb, previous bulbs. So that's why there is an inventive step in that case. So in that way we can think of about inventive step. The next is capable of industrial application. So the invention is capable of being made or used in an industry. So it means a person who come up with an invention and says it is helpful in various ways, but it is not the case in case of capable of industrial applicability. It should be a specific thing. It should solve a specific problem. It should say, for example, if it is a drug, So a person should have to tell that it is treating the cancer disease, or it is treating any other specific disease, so that it there should be an industrial applicability should be applied. It should be useful for a particular thing. So these three criterias are checked in case of patentability search. Though lot of invention may be capable of industrial application, but there should be novelty, and there should be inventive step. So these things are the most priority for the patentability search. Let's have an example. So there is in composition, a person have come up with an idea, and it is having three elements, A, B, C, and it is solving a problem which is wound healing. So it is a wound healing composition. A is buckwheat honey, B is silver nanoparticles, and C is lactic acid. Now we performed the search and found there is already prior art which is a topical composition, and it is also having three ingredients. One is honey, A is honey, B is nanoparticles, and C is acetic acid. So I would like to know, uh, would wound healing composition be patentable or not? Anyone wants to answer? So there may be it may be patentable or it may not be. So based it depends on the similarity of both inventions. For example, buckwheat honey, if it is providing a different qualities as compared to the honey which is available in prior art, and it is giving the some advantage over the this honey, or silver nanoparticles, because in the prior art, it is just a nanoparticle, but a person with the new invention is saying that it is a silver nanoparticle. He is being specific in silver nanoparticles. So it has been checked that those nanoparticles which the prior art is saying about, what are those nanoparticles, or is it specifying any nanoparticle or not. And C is lactic acid, or in this case it is acetic acid. So what is the difference in both cases? So based on that, what are the advantage over the prior art, it can be patentable or it may not be. So in case of patentability search, there is one more thing. When we run the search, it helps in drafting also. If that search has been performed before, and you have come up with this prior art which is also disclosing these three ingredients, so you can mention this prior art in your draft, that we have come up with this prior art, but our invention has these advantages. So if you are already specifying those advantages in your draft, in your disclosure, before filing, so it would be giving a benefit, and during prosecution, when you can give the arguments over that. So in that way also patentability search is helpful. Now the second one, it is freedom to operate search. So what is freedom to operate search? When patent is granted, now you are looking for launching a product. So to investigate whether a given product is going to infringe already existing patent rights, it means if you are launching a product in a particular territory, and when you so there is already there is no existing prior arts available, so you want to check those prior arts. So in that case, freedom to operate search are conducted. So it provides guidance regarding product design decisions. It helps to identify the patent that could be licensed. So in this way, freedom to operate search are conducted. So in case of freedom to operate search, there are other things which should be considered. First thing, legal status. When you run the freedom to operate search, the patents should be alive. It means status of the patent should be enforceable or alive. It means that patents or unforceable patent are not considered in case of freedom to operate search, because uh, only alive patents because as Kavita has discussed yesterday, that patent life is 20 years. And if that 20 years already completed, in that case, anyone can exploit those patented ideas, because after 20 years it is expired. So that product can be used. But if it is alive, in that case, that already available prior arts can be exploited, cannot be used. So one thing is legal status. Second is scope of claims. In case, as Kavita has discussed the structure of patent also yesterday. So you have seen that there is a one part which is called claims. Claims are the heart of invention, heart of any patent, and it protects it gives the protection to a for an idea. So what is the extent of protection provided by the claims? So if it is covering in that claim part, the prior art covering that thing in the claim part, in that case, that new product cannot be launched. And also you have to check the territories, the countries. For example, if you want to launch in India, you have to check that that product which you are going to launch should not be available in the form of patent in India. No, and if you want to launch in US, you have to check for US. So in this way, for different countries, you have to run the search accordingly. Let's see the example. You want to launch a product A, B, C, and D. It is having in these four ingredients, and a prior art which is already available having A, B, C. So I would like to know from your side that is it infringed or not? A, B, C, the prior art, is it infringing the your product or not? Anyone, any lead? So yes, it may infringe your product because A, B, C, these three ingredients already available in the form in this prior art. So, but if there are different percentage, or if it is having different effects, in that case, you can check for those things. You can prepare the report accordingly. But if you find out that no, it is infringing, then what you can do? In that case, you can do licensing with that patent holder who is having already available, which is already patented in that country. So to that person you can license, or you stop the production, or you design around. You again think how things can be changed in your product, and accordingly after that you can design around and launch the product accordingly. So this is one way of search, prior art search. Next is invalidity search and opposition search. So to determine the validity of patent uh, before launching of the product, as you run the FTP search, FTO search, freedom to operate search, which we just learned, Now you found out in during that search, and you prepared a report that these are the prior arts which may infringe your product. You may going to infringe that these prior arts, these patents. So to validate or to check the strength of your product, your patent, invalidity search or opposition search is performed. So for this thing, you consider the patents, you may consider the non-patent reference also, which may impact the claims of a specific patent. So in that case, determine the enforceability of your own patents, to prepare invalidity procedure against others' patents, and to prepare defense against lawsuits claiming others' patent infringement. Basically, you prepare the evidence of use for this invalidity search. Using this tool, using this invalidity search, you prepare the evidence of use, or you check the strength of your patent, your product, basically patent. You are not going to you are not infringing. Or one more way, more reason of running this search: you already launched a product, but that person, other person who is having the same patent on this product, and he sent us lawsuit, he want to send a lawsuit. So that person, other prior art patent holder, may sorry may run that search to check the strength of his or her own patent. So for that reason, invalidity search also performed. As we learned in the last search about that, there is a wound healing composition which is having buckwheat honey and having silver nanoparticles. So this is the product patent which you are going to launch, or you have launched. Now prior patent which is having topical composition having bee honey and nanoparticles. Sorry, there is some typing mistakes. So now you want to you would prepare a chart that what are the contents, what are those things, on the basis of that your patent strength is getting weakened. It is making weak your patent. So there may be percentage based, or there is a difference between the nanoparticle. So what are those various things which is validating or invalidating your patents? So based on that, you can take the decision. And for that, if you found out that yes, your patent is invalidating or others patent is validating, in that case you can do the licensing, or you can do some design around things. These things again can be done in the form in this search. Now the next is technology landscape. So technology landscape is to explore technologies existing in the given technology domain. So as I have come up with an idea that I want to solve any specific problem. For example, I have an idea of a toothbrush, and that bristle part is herbal, which is made of herbal thing. Now you want to check, you want to see, you want to validate that this idea is novel, or you want to launch a product. So how you will check that yes, this is a new idea and you should go ahead with this idea? So for that, a technology landscape can be run, and after running that landscape, you now know that these are the different areas, these are the different technology, or these are the different competitors who already are producing this kind of herbal bristles. So you will get an idea, you will get a snapshot that these are the already available things. Now you check what are the different gaps, what are the various areas where the research can be run. So for that effective planning of research and development activities, to avoid reinventing the wheel, it means you are not again doing that research, you are not again reinventing the same invention. So uh, that that decision making can be done using that technology landscape, and decision regarding entry into the market, and determining the void spaces or unexplored areas or those gaps, or identifying potential partners or competitors. So for example, you come up with a list of competitors or already available assignees who are working in the same field. Now you have some more advantage in your invention, and you can partner with those assignees, potential assignees, in the sense of, for example, you are not having funding, but that assignee who is already have that type of technology can partner with you and can provide the funding to you, and you can give your new invention idea or you new technology to that person. So in that way you can partner with those people. So patent landscape reports provide a snapshot of the patent situation of a specific technology, either within a given country or region or globally. So it gives a fair idea about available technology in that particular area. What are those gaps which can be filled? What are those solutions already available for that particular technology? And what are those potential partners or competitors, and where, in which country this technology is in good condition and where it is not in good condition. So accordingly you can choose your market as well. So this type in under technology landscape there are different ways of searching. So one is state of the art search, one is wide space analysis. State of the art search is helpful in getting the knowledge about what are the available solutions already, and one is wide space analysis. So what are those gaps or unexplored areas where people are not working already? So such things can be understood with the help of technology landscape. Now next is uh, what is the already what is the relevance of prior art? So in the case of, there is a one very famous case of turmeric patent. Turmeric patent case as we all know, turmeric powder is widely used in India. It is used in cooking. It is used in wound healing. In many medicines, it is already getting used. So in 1995 in US, two inventors filed a patent on turmeric. So let's read about it. Uh, turmeric, turmeric powder is widely used in India as a medicine and food ingredient and a dye, to name a few of its uses. And for instance, it is used as a blood purifier in treating the common cold, or as an anti-parasitic for many skin infections. But in 1995, US awarded patent on turmeric to University of Mississippi Medical Center for wound healing property. And the claimed subject matter was the use of turmeric powder and its administration, both oral as well as topical, for wound healing. An exclusive right has been granted to sell and distribute. Then CSIR had objected to that patent, which was granted, and provided documented evidences to the prior art to USPTO. So CSIR did prior art searching that this turmeric thing is already getting used in our country since long, and it should not be patented. So, though it was very well known that the use of turmeric already is getting used in household in India, but it was very difficult task to find out the prior art which is saying or giving evidence about the use of turmeric. Uh, but uh, but a single document which was saying about the turmeric use in Indian households was given, and there were some other 32 references also provided, which was saying about the same use. Then, on the basis of that prior art, USPTO revoked the patent, stating that claims made in the patent were obvious and already available in the public domain, and then on the basis of that patent got revoked. But after that there is one more initiative started, which is called which is in the public domain. Traditional knowledge library got built, and on in that database in India, we have feed the data about traditional knowledge. So as neem is already available, and we use this as an antiseptic thing since long. So that type of knowledge is available on traditional knowledge library. So this is the importance of prior art. It should be documented, and it can have it it can have this type of effects like USPTO revoked that patent. One more one more case, which is called Apple versus Samsung. In 2011, Apple sued Samsung, saying that Samsung has copied its design of the iPad for its Galaxy Tab. And in defense, Samsung attorneys contended that Apple had patented very common design, and which is seen often in movies. So as you can see in the picture, that there are two guys having dinner and seeing some video on their digital device. So this scene is from a very old movie which was released in 1968, which is 2001 A Space Odyssey. So in the evidence of prior art, as a evidence of prior art, Samsung referred that scene from that movie and told in the court that this is already available in public domain. So Samsung, Apple has not built any new thing; it is already available. So this is the importance of prior art searching, that and what things can be referred as a prior art. Even the movie clipping can be given in the evidence of use. So this is the one case, very famous case and interesting case. Now, how to perform the search? There are different type of search, but how we should perform those searches? So there are two ways of searching. One is keyword based search, and one is classification based search. As I have taken the example of skin composition in my example, so I want to run that I want to know about the skin composition. So what are the various synonyms for skin? This skin, for skin, it may be a topical, it may be wound. So these synonyms we use for keyword based search, and these synonyms are combined with the or operator. So based on our concept, for example, we want to search for wound healing composition or skin composition. So we will do here skin or topical or wound, and we will uh, make it and with the composition. So skin and composition. So using different operators or based on that, we run that search, keyword-based search. And one more effective way of running that search is classification-based search. For skin composition or dermatological disorders, there is a one code already classified. It is called drugs for dermatological disorders. It is A61P17. So what is A? A is human necessities. A61 refers to medical or veterinary science or hygiene. Then P, specific therapeutic activity or chemical compounds or medicinal preparation. And 17 is drugs for dermatological disorders. So there are different types of classifications available. So one is IPC, one is USPC, which is given by United States, and one is very effective classification system, which is CPC, corporation patent corporation sorry CPC, so corporation patent classification. So this is a very commonly used classification system, and this is the snapshot of that CPC. So so some countries already having their own classification system. So as US has their own classification system as USPC, Japan has their own classification, and that IPC is from WIPO. WIPO has given that classification system. So based on our territory or our search type, we can select these classification system also, but CPC is the very commonly used classification. Now, what are the various search engines? What are the various databases? So databases are which means that the data, the organized data, which is available on that database. It is that these searches are not just like the Google search, that we have typed something on Google and we got some results. And I think nobody will scroll down more than 3-4 pages. These are the different types of search, very systemized searches, and for that we use these databases. So for patents, there are different databases. These which I have named here are free databases, which is available freely available to public. There are some other paid databases also, which also having very systemized data using different operators. They give the using the very systemized search strategy, give very relevant data. So on the basis of our search type, we also select these databases. And for NPL, it means non-patent literature. We can use these databases. So rather than using free Google, we use Google Scholar. We use, if we are having search related to medical field, we use PubMed or Science Direct. So based on our domain, we select the database as well. So we will check these search engine, and let me open my browser so that I can show you that how these databases look like. Hope my screen is visible.
Yes, ma'am.
Okay. So one database is Patent Scope. So here we have different options. So here, this is the search option, where we have different options like simple search, advanced search, or field combination search. So in simple search, this is the page for simple search. And now, yeah, here we have different options. For example, any field, full text, ID number, classification, names, and publication date. So for example, I want to search for skin composition. Or maybe it is open, it was open since long, so that's why it's not giving any result. So you can see that it is giving almost 85 474 results. So that's why we frame the search uh, very systematic manner. So we use different operators, and based on that we run the search. Also that search, this is a simple search option. We can use the field combination as well. So you can see that here the front page, the publication number we can put the application number and publication dates and titles. So in this way we can combine our search. And I would like to show one example also here. I think there is some error right now. Let's move on another database, and after that we can try it out. There is one more database, which is eSpace. So here we can search in the same manner. Here we have one option is advanced search, and we can type down the title which you want to search for, the publication date you can type down, or different different options are available on this database also. For example, you can put the text fields in title, abstract. So as we have learned about what are the different parts of a patents. So title, abstract, based on that we perform that search. There is one more database which is called Google Patents. So here also we can perform the search. Here we can write down one hailing composition. You can see there are a lot of results. So that's why we combine the keywords with classification uh, to make it more specific search. So these are different databases for patents. Now we can see what are Npl databases. So we can see here Google Scholar. One database is Google Scholar, and here we can search out our concept or our idea. And here one more database which is called Science Direct. So this is a database for searching the non-patent literature. You can type down the keywords or based on that. Based on your idea, based on your concept, you can combine this skin with the other other words like skin and wound. Based on your concept or idea, you can search out. And as I have showed in my presentation, it's available, visible. So here, these are different databases for patents or for NPL, which we have searched out. Here, one more database, which is Indian database in pass. We can export that database also. How it look like. This is the Indian database where we search based on our title, abstract, or complete specification, or even we are having that number, we can search that number. For example, here we can see 236542. Then you have to type down one OTP, which is a very common trend in our Indian government size. I think there is some net issue. That's why it is not giving results right now. Okay. So there is no document related to that patent. So if we are knowing that number exactly, we can type down. Even we can type the applicant name. So here you can see Serum Institute. So we can check what are the patents for serum. No results. I think there is some issue right now. It is not showing any result. Or I think I think it should be giving some results. Yeah. So 550 patents for SRM. So we can check based on our applicant what are the available patents for this applicant. So in this way we run our searches. And I would appreciate your question and answer questions, or we would like to invite the discussion here. Any question? And I would like to give.
Ma'am, it was really a very informative session. And the way you browse through all the Google patents and everything, it was really a wonderful, ma'am. Thank you so much. And I have a clarification. In pass is one thing where we can see the patent which we have filed also, right? To understand the status of our patent which is filed.
Mhm. We can, INPAS is a Indian patent database. You can check the status here. If you want, if you have that application number, so you can type down that application number and you can check the status. If you have that number, we can check.
Is there any from other participants?
This is a feedback form, which I would request to everyone if they can fill up that form, and it would be helpful. And if they have any suggestions on it.
There are 2 feedback forms. You can fill both.
Yes, ma'am. You
so
also share
Yes.
these forms, this both form tomorrow from yesterday's session and today's session. I would appreciate the questions because it is the all theoretical thing which I could deliver. But if you have any specific question, then I can answer those questions.
Ma'am, to be very frank, as an academician, pre-art search is very new to us. Entering into IPR as such is new to us because most of the concept may it be white space search or a novel search, everything is very new to all of us.
Yes, definitely. I
Probably it is
understand.
actually a learning session than a clarification session.
That definitely, I understand. You even can approach us on our this email ID. I'm sharing my information. Also, we provide specific basic or advanced courses also for IPR learnings. So if you are interested, you can approach us for that also. And one question, I think it is on licensing. It was asked yesterday also. So actually, what happens? There are different phases of any patent or product. So after getting the grant of the patent, there is the commercialization part, and for that commercialization you do licensing who already having the same technology or working in that particular area. So for that you can firstly check who are those possible or who are those available competitors or available assignees who are working in that particular technology, and then you approach for licensing thing to that those assignees. I think this is a capability building program, and one session is specifically dedicated to this licensing thing or law thing. So I think it would be get addressed in coming days.
Is there any other query for the other participants?
Hope I was clear during my presentation, and hope you have learned a lot. And it was really great session for me.
Yes, ma'am. It was actually.
What will be the application fee for patent in India? So actually, it depends on what in so that depends on if you are going to file as an individual inventor. For individual inventor, it is 1600. That fee is 1600, and for other things like big entity, it is a separate fee, and based on your application, I mean, what type of status of your company or inventor. Sometimes you are going to file as an startup or MSME or as a big entity or educational institute. So based on that, the fee varies, but basic fee is 1600.
Thank you so much, ma'am. just an information which I want to pass on to the participants. It is actually a 15-day series, and for attending each day, you will be getting a certificate. This is the second day. Tomorrow, we are not having any session. It starts from 27th. So leaving out Sundays and government holidays, we have fixed it for 15 days, starting from yesterday till February 10th. This is just an information. Interested participants can look into it. If you have done your feedback link, we will definitely post the information about other sessions in your mail ID. Thank you so much. Deepika, you can formally propose the vote of thanks.
Yes, ma'am. Good afternoon, everyone. It is an honor to propose the vote of thanks for today's session. I thank the Almighty for making today's session a success. I extend my gratitude to our speaker, Ms. Nidhi Agarwal, for taking the time to be a part of the FDP on research and IPR and for the wonderful session today. I thank all the participants who have taken the time out to attend today's session. A big thank you to our secretary, Shri S. Abhishimal Jain, and our associate secretary, Shri R. Ashok Kumar Mehta, for their constant guidance and support. My special thanks to our principal, Dr. S. Padmavati, and vice principal, Dr. S. Rukmani, for giving us encouragement we always need. Last but not the least, I would like to thank Dr. S. Tedipa, our technical team and internal training team for all their support and coordination. Once again, I thank you all.
Thank you so much, ma'am. Nidhi ma'am, there is one query which is posted there by...
Yeah, I was just answering for that. You can apply for training in different IP firms or different companies who also provides the training in IP field, or you can check for the available post which is not asking for previous experience in IP. If you are having R&D experience, that is also good. Or this is the way of entering in any field. In any ways, in any field, you require some training.
Nidhi ma'am, can you share your number with me so that I can contact you for the certificate on IP for our students? We can have it as a value-added post.
Yes. 1 minute, I share it. You get my number? Have I posed to right person?
Yes, ma'am. Yes, ma'am.
Okay.
Is there any queries from other participants? If not, we can wind up the session.
I think we are wrapping up before time.
But it was actually an informative session, ma'am.
Thank you so much.
That is the first thing which any inventor should know, whether the idea which they have is already available, not only within India, but then in other countries also. And WIPO is one such website which you can really have an exhaustive search.
Yes.
It is very informative, ma'am.
So for patents, there is patent scope of WIPO, patent scope database, which is a free database and provides good results if you are checking for patentability. For patentability search, WIPO patent scope is good, but for FTO or some invalidity related searches, we definitely require some better databases like paid databases to avoid any data avoidance.
Thank you so much, Nidhi, ma'am. Thank you, ma'am.
Thank you so much for attending this session. I'm really feeling happy that we have good strength of participants.
Thank you so much, ma'am. Looking forward for other sessions with you, and our institution may contact you for the certificate courses on IP if the students are interested. Thank you.
Thank you so much.